and it looks like we have Judicial Meetings has joined.
Okay, great. Thank you and good afternoon, everyone. So we are here for the October quarterly meeting of the Bench Bar Foreclosure Committee. It's now 3:04 p.m., so I will call the meeting to order. And if we can just have the attendance noted. Becky.
Yes, we'll do, Your Honor. Would you like me to name everyone who's here?
I think, yeah, just so the,
Sure.
the minutes will be reflected as well.
Absolutely. Judge Bayo as chair, Attorney Jeff Gentis, Attorney George Daenerys, and Attorney Maria Salato, and the Honorable Judge Spader joining us, as well as myself, Rebecca Schmidt.
Great. All right, and welcome, Judge Spader. All right, so folks, first, sadly but not unexpectedly, you received notice that Judge Abrams has resigned. He indicated in his note, please accept my resignation as a member of the Bench Bar Foreclosure Committee. Under current circumstances, I don't think I would be able to make any real contribution to the good work of the committee. That was sent to us back on September 4th, 2024. I did alert, he did as well, but I did alert the Chief Court Administrator's office and requested authority to seek appointment of a replacement member. I have not yet received that authorization. So hopefully that will happen soon. And hopefully we'll have a new member coming to our committee. But as of right now, we do not. And I see that Attorney Sternberg is now with us, so we can add her to the list of those attending. The next agenda item is approval of the minutes of the July 31st, 2024 meeting. You all should have received a copy of that in the packet that Becky sent to everyone electronically. So I would entertain a motion. Anyone?
So moved. Second.
Any discussion? All those in favor?
Aye. Aye.
Aye.
Aye.
Aye.
All right. And I think that was everybody. No abstentions, no votes. So that motion passes. With regard to the old business, the quality of life improvement suggestions, consistent with the discussion we had at the last meeting, Becky put the few suggestions that we did have, you'll recall, and it's reflected in the minutes, that she would put together a bullet point list of the suggestions to circulate, and then to see if there were things that people thought were appropriate to submit to judges who handle foreclosure matters. Some of them, upon review, aren't really that kind of suggestion, it appears to me, but I want to open it up for discussion. Some of them, we don't have a lot, but some of them we may have addressed already, and some of them seem to be more for things for this committee to consider. But there were certain suggestions that might be appropriate if everyone wanted to put together a list and request permission to circulate those for general awareness purposes to the judges who handle foreclosure. That might include being mindful of the first bullet point, being mindful of self-represented parties, possible difficulties with using remote technology, the appearance of impropriety or overfamiliarity with plaintiff's bar chart calendar, which is the fourth bullet point, the lack of consistency in processing and data entry on motions to substitute, which is a different issue, and again, one that we agreed to undertake discussion on. So I don't know how people feel about, I know originally we thought that there might be some things in here that it would be appropriate to request permission to circulate to other judges handling foreclosures. I'm not sure from this list how people feel about that, so I would like to open it up to discussion. Anyone?
Well, I will point out, just because no one else wanted to speak, I did do a meeting of foreclosure judges for doing this, the foreclosure docket this session and raised the issues that have been brought forward. Well, Becky actually did it for me. Brought forth the issues of what wanted to be passed along to judges as far as the consistency on the dockets, issues like that. So we did bring it up. We'll continue to do that. Ideas that come out of the committee that should be addressed with judges handling docket, because I think that's what one of the hopes were on that point. And yeah, I can say on the other thing, in the background, you're working on the clerk's office for uniformity and issues like that. So I appreciate that you're addressing those issues, Judge Bale.
And thank you. I neglected to thank Becky, so thank you for reminding me, Judge Spader. Judge Spader was kind enough to include me in the foreclosure roundtable. Unfortunately, I was in the middle of a jury trial, and Becky was kind enough to agree to deliver the report from the committee for me. So between her and Judge Spader, I know that we were well represented and covered. I'd like to hear from what anyone else has to say. I think that is probably, at least from my perspective, but again, I'd like to open it up and hear what you have to say. That's probably the best forum for that, is to do it through the foreclosure annual meeting that is held with specifically judges who handle foreclosure, and also to the extent there's anything that's a bigger issue, to address that at our annual Connecticut Judges Institute. We did have a presentation on self-represented parties, so it addressed some of the issues that were raised with regard to those concerns. It would appear to me that those would be the appropriate and the best way to get the information out, is for us to have them filtered through those avenues. But again, I'm happy to hear if anybody else has anything to add on that. And we should continue to, even if you agree with this, continue to raise issues that come to mind so that we can keep those updates going. Anyone else have anything to add? Attorney Gentis, I think this was originally your suggestion, so I don't know if you have anything to add to that.
No, it sounds great. Just how many judges is it? Is it like 14? Is it 20? I can't remember like who's rotating and who's not.
It's kind of within that range, right? It varies a bit, but Judge Spader, I think you're muted, my dear.
Yeah, it's around 15 to 20. Some districts do have a rotation, while some districts have dedicated. So yeah, it was around 15 to 20 attendees.
Cool. Sounds good. Thanks.
All right, great. Now on the motions to substitute, James unfortunately is in the midst of his hearings, as you're aware, but he did submit a proposal. He was going to present on this. If he doesn't make it in time for the meeting, you have his memo. If anyone has any burning desire to address it, I'm happy to hear you. Otherwise, I'd kind of, since it was his, he undertook this one and was going to present on it. It might make some sense to hold off either until he gets here later or to save it to the next meeting. However, if anybody wants to be heard, I'm happy to hear from you.
I would defer to Attorney Salato and Generous on this one. It's because they're both going to see one tax lien buyer substitute for another, or mortgagee for another.
Fair point. What do you folks have to say? Do you want to talk about it now? You want to wait for James?
I think we should wait for James.
Attorney Generous? Okay. All right, great. So we will put that one on to take out of order if the parties are okay with taking a vote at the appropriate time to take the agenda item out of order. If Attorney Pocklington does not make it, since he just gave a real-time update to Becky telling her that he is still going strong with his hearings, then we may just put it over as old business again for the next meeting. All right. Next, I wasn't sure at this time. We kept it on because it is old business, but based on the discussion we had about the CFPB education suggestion and waiting until that was ripe, I wasn't sure if there was a need for us to discuss anything for this meeting or not.
So many people anxious to speak today.
I know.
You know?
Your Honor, Has it come out of comment period yet? I know it came out of comments in September, but I haven't seen anything further from it.
I haven't either. That's why I think this may not be ripe yet, but we just sort of kept it here to make sure because it was an open issue. I just don't know if it's ripe for us to discuss at this point. Shall I interpret the silence as no?
I haven't seen anything, and I usually rely on Attorney Gentis for information on what all federal boards and agencies are doing.
I guess I could circulate something if it would be helpful to the committee, and the members can do what they wish with like the FEMA moratoria that are out there that are affecting things. That's not CFPB directly related, but perhaps it would be useful, you know, subject to anybody who those who represent mortgagees weighing in on things. But we think it's a pretty we provided it at a mediator's request, so we were trying, you know, it's pretty dead middle. So I'll circulate that along, and then sounds good on the rest. I'm out if the other stuff's not right.
All right. Anything else, folks, on that one?
No.
All right. The next one, I have some good news to report. You'll recall that there had been a recommendation made at the last meeting by Attorney Generous, and he submitted proposed language that everybody was okay with regarding the recommendation that there be added language that the committee be required to notify the plaintiffs of sale results within a specific period of time. That request was submitted to Judge Bellis, who actually was in favor of it also. We submitted it to the Chief Court Administrator's office. It was well received and approved. Becky has taken the steps necessary to get the proposed language added to the standing order. And Becky, I know that we thought it was going to be done by today's meeting. I don't know if it was, though. The actual
not
implementation.
Posted yet. It is,
Okay.
Your Honor, it's still pending final approval to be posted, but I do expect that any day now. And
So
it's
that's
the,
great news. Go
yeah,
ahead.
it's the JDCV 81 that we updated, just so you can all be on the lookout for it. And when I see it, I can certainly circulate to the group that it's
Please,
been posted.
if you could do that, that would be great. And it would, just so you're aware, in case you want to flag it when it comes through, so you don't have to read through the whole order again to try to find it. And the added language will be, assuming it shows up where we've put it, it will be at the top of page 3. Is that still true, Becky? That's where we had it on our draft.
That is true, unless they do something fancy with the fonts for whatever reason.
Yeah.
The markup I saw was that page.
All right. So that's great news, and it's nice to see that another suggestion that has been made has been implemented. So that's everything we have for old business. And I will open it up to new business. There's one item right now that I wanted to just throw out there to see if this was something anybody wanted to comment on or not. And that is, you can see it's noted on the agenda as timing of supplemental judgment. Having served now in several different courts that doing the foreclosure stuff, I noted that was a technical word, stuff. I've noted that we all handle the timing of supplemental judgments differently. I had to, when I was in New Haven, there was a longstanding order. It was one used by Judge Cordani, used by Judge Spader, used by Judge Abrams. It had been used there for a while, and it's still being used. And that is that the supplemental judgment is to be filed 5 days after the committee's return of sale. And that seemed to make perfect sense. And so when I came to Hartford, I began using that same template, and it was foreign to here. So I stuck with the order that was used in Hartford because that is what they were used to, and that I didn't want to buck the system, and it didn't seem to harm anything. And that was that those of you that practice in Hartford know that is that the supplemental judgment is to be filed within 90 days of the notice that goes out approving the committee's reports. Now, in New Britain, they use an order similar to, but different from Hartford, and it also uses the triggering time as the approval of the committee's motion and report. But in New Britain, the supplemental judgment is to be filed within 30 days of that notice. Now, the rule on it is that it's discretionary. It's up to the judge. So I don't know that, it's not that we can point to anything and say that it has to be done a particular way. I just wanted to throw it out there to see if there was any thought among the committee that there should be some uniformity, absent some extraordinary circumstance or unusual situations, which of course the judge has discretion on, but if there should be a recommendation of, or not, of handling the filing of supplemental judgments in the same way cross jurisdiction. Does that make sense? The question, not necessarily the answer. So does anyone have anything to say about whether that is something that is should just be left alone, or that there should be some discussion by our committee about?
I would tend to agree there should be some uniformity. I don't specifically handle supplemental judgments. I'd have to confer with the attorney who deals with our post-sale motions. I know that sometimes there is a delay in getting supplemental affidavits of debt from our client. So I do appreciate having the 90 days to do it in Hartford. But I would agree that it would be helpful to have some uniformity between the courts and trying to determine what that time frame is.
Anyone else?
I figured it would be Attorney Generous would say, hey, the more time is necessary. And I agree, it takes time to get those things done. I mean, the 5 days is a little aggressive, but it's not like I punish anyone for not doing it within the 5 days. I just want to kind of keep it on people's radar, because when money is sitting there, defendants who are entitled to some of that leftover funds have to sit around and wait for the plaintiff and the secondary affidavits. So it's like, the longer it takes to get those motions done, someone that just, lost the premises and could be in need of some of those funds to help them in their next location. And I don't like to prejudice them by sitting around. But granted, 90% of the times it's a motion for supplemental judgment just to close out the file because there was no equity. It was a U.S. party. I get that. But I just have those concerns for the owners of the equity redemption who may have some funds available to them, and I don't like the cases sitting around for that purpose. But uniformity would be nice. I just haven't been able to myself either figure out what kind of uniformity to pitch to my fellow judges.
And I don't necessarily think that the New Haven time frame is shorter, though, Judge Spader, because the time frame in New Haven runs from the return of sale. And that could take however long. Sometimes it's longer, whereas Hartford and New Britain have different amounts of time from when that order is sent out on the approval of the committee motion. So it may not be that it's shorter, it's just that it's different. You know what I mean? I mean, that's how I viewed it.
No, I agree. Just the one thing that I just don't want the files forgotten about, because I want to make sure that we disperse any money that needs to go out to the right parties to satisfy, money's not doing any good sitting in court. So I like to just try to get us to the quickest point of getting rid of the money to help everyone.
And I think that's the whole point of the time frame generally. And some of the orders do say if you don't file it within the time frame that there will be a disposition. So I mean, the purpose is the same. The only question is, again, just because we have different things happening in different courts, whether it makes sense. If we get past the first, I've heard now from a couple people who think it does make sense. We haven't gotten to the question of what uniformity makes sense, but at least that idea. But others that agree or disagree, I'm happy to hear from what we have to say.
I would leave this up to the court. It's just not it's not the biggest issue for people. When we talk to people about recovering their proceeds, it tends to be logistics and just sort of complications that aren't necessarily like, hey, I got this, you rarely get the person, at least in my experience, which is something, but not everything. You rarely get the person who is so on top of, I have excess proceeds I need to recover, but I also let my house with equity go for foreclosure sale rather than list it and do those kinds of things to maximize their value. So it tends to be like, hey, I think I have some extra funds. That tends to be the inquiry. Obviously, like, you know,
You'd be surprised.
Okay.
You'd be
Yeah.
surprised how many teams.
no, I'm
You'd be
just
surprised.
saying that there's the, you know, that tends to be where we get, and obviously, you know, I don't need to, I'm just saying in terms of, I appreciate the concern. I don't know that it's, I would say like by comparison sake, the quality of life stuff that we discussed earlier is more important and experience more broadly. But yeah, whatever would make sense. I don't just as one borrower's counsel, I don't have a strong view on it.
All right. How about, thank you very much for sharing that. And I understand, you know, everybody has different experiences with your clients, you know, but, and so your world is one where this isn't a huge impact. I will tell you, I agree with Judge Spader. You'd be amazed at how much activity there is on this issue.
No, and I'm
so,
sure it's much
but
greater.
I
too.
get it. I totally get it. Everybody, that's one of the nice things about the diversity of this committee. But let me just ask Attorney Salato, Attorney Sternberg, do you have anything to add?
Not particularly. I mean, I think it should be uniform throughout the course. I think that would be easier. The only delay I ever have on my end is that the committee doesn't notify me that they've returned the proceeds to court. So,
Which has now been addressed thanks to the
Thank
recommendation of Attorney Generous. So
yeah, I
All
think
right.
5 days is probably a little short, but I think maybe 90 days is probably too much time.
But remember, they're different triggering start dates.
That's true.
So in New Haven, and I don't know if I reached out to Bridgeport, but I don't know that I reached out to the right person. But maybe you remember if it hasn't changed from your days there, Judge Spader. Was it the same thing, 5 days from return of the sale?
The same 5-day order. I wrote all those Edison templates.
Yeah. So, well, because I know New Haven came before you, so I wasn't sure if Bridgeport, but I mean, New Haven made sense to me. That's the template I wrote for Hartford, but it was different here. But I get it. If you just hear 5 days, it sounds like, oh my God, that's really fast. But again, it's 5 days from return of sale. Now, maybe there's some way to merge the two and make a suggestion of using that return of sale as opposed to, you know, the other courts. And again, I only did the dedicated courts. I didn't look at the other ones yet because I just wanted to raise the issue. But at least Hartford and New Britain, the triggering date is when the committee submits their motions for approval. When the court approves those motions, that's the date that controls it. It says, you know, Hartford says 90 days from notice of this order. New Britain says 30 days from this order. New Haven and Bridgeport say 5 days from the return of sale. So there's extra time built in based on when the time frame starts to run for New Haven and Bridgeport. So don't just focus on the 5 days because it sounds scary. Like if I said 5 days from issuing of the notice, obviously that would be unrealistically short. But I don't know that it's really all that big of a difference from the 30 days in New Britain. The 90 days in Hartford does seem long to me. But that's just me. And, you know, as Attorney Gentis pointed out, we all have different experiences. So we want to hear from you folks. Well, why don't we do this if everyone's okay with this? Because I appreciate the comment on the first part of this, and it sounds like there's still some wheels turning on the second. I can make the suggestion on behalf of the committee to Judge Bellis that in looking at this issue, we see the differences and the committee consensus, if truly that is our consensus. So let me know that if this is a fair statement of where I think we are, is that there should be some uniformity on the issue. And then see if she's receptive to that. If she is, then we can figure out the second step, and it'll give you some time to think about that as well. I'm happy to hear alternative suggestions if you prefer. Anyone?
Sounds like a good plan going forward.
Okay, thank you. Anyone else?
I before offering any sort of suggestion, Your Honor, I would just need to speak with Rachel, who's the post-sale attorney in our office, to see what kind of time frame would be acceptable or appropriate for us to suggest. So I can certainly look into that and then send Becky an email.
Yeah, and that's why I don't want to put anybody on the spot today, because it sounds like there needs to be additional thought put into that. But as to the first part of suggesting that there be uniformity, do you have any hesitation on that today?
No, Your Honor.
All right, anyone else? So is it fair to say that we have consensus on that proposal for part one, and we'll discuss part two at the next meeting? I'm seeing nods in the affirmative. How about we'll take it as a motion to make it easier. Is there a second? I'll
Second.
move. All those in
Second.
favor?
Aye.
Aye.
All right, any abstentions? Oh, hello, Attorney Pocklington.
Unfortunately, I do have to abstain because I'm not even
Yes.
sure what we're talking about. But,
That's totally fine. All right, so then Becky, we'll put that on the front burner to make the proposal as to part one of that. And then that leaves us to two things. Attorney Pocklington came just in time to discuss the issue of the motions to substitute. But before we move on to that, let me just ask if anybody else has any other new business.
Your Honor, the issue of ongoing scheduling will be new business.
Thank you. That's right.
Yes.
Yes. Thank you. And I had that
Mhm.
right here, and I'm glad you reminded me because I obviously was going to forget. So this is the last of the current series of meetings that we had scheduled. So we need to now select the meetings going forward for the next term. Becky has put together the list. If we follow the same quarterly schedule, she has January 29th, 2025, April 30th, 2025, July 30th, 2025, and October 29th, 2025. That would be the proposal if we continue on a quarterly basis, which right now seems to be working. And so I'd like to open that up to see if there's any discussion before we put it to a vote. You are, I thought you were muted. I saw you looked like you were talking and I couldn't hear you. I'm sorry, Attorney Pocklington.
No, the one caveat that I would make, Your Honor, and I see is I'm now 0 for 2 of our last 2 meetings due to the current scheduling of the Stanford remote hearing docket. I was wondering whether there was appetite in the committee to push us back to 3:30 as opposed to 3 or something along those lines, now that we know that there is likely to be a fairly common conflict.
That's fine with me. I mean, quite frankly, I think, and I don't mean to speak for Judge Spader, I think for the judges, it's easier to do it a little bit later in the day, too.
It is. I was running around today between remote hearings, habeasing in Department of Correction guests.
Yeah.
So yeah,
I mean,
3:30.
honestly, even
3:30 is
4,
easier.
I
No, we don't
wouldn't
wanna
go
keep
much
it
past 4 because
I wouldn't go
but-
past 4 either because, as you can see from this meeting, everyone's very talkative and they want to go on for an hour just on minute approvals. But I would say 3:30 is probably a better start time.
All right. So anybody else have anything to say before we put this to a vote?
My 5th grade coaching obligations are on Tuesday, Thursday for the next multiple sports seasons, so I'm good.
So Wednesdays still work for you, right?
Wednesdays are still great.
And
I'm being
3:30 is
ridiculous,
okay.
but yeah, 3:30 sounds great. Happy to accommodate.
So is there a motion to accept the proposed schedule with the start time of the meeting being 3:30?
So moved.
Is there a second?
Sure, I'll second.
Any further discussion? All those in favor?
Aye.
Aye. And I think that was everyone, but any abstentions, any no votes? All right, unanimously passed. Thank you, Becky, for that. Any further new business before we go back to the motions to substitute? I will interpret the silence as a no. And Attorney Pocklington, I will just ask, is there any objection to taking the motion to substitute out of order now that we have Attorney Pocklington with us? We passed it for that reason, so I just want to make sure we're good.
No objection.
All right. All right, so with that, your memo has been circulated. And so we will turn to you, Attorney Pocklington, if you'd like to say anything about it.
Thank you. I assume everyone's had a chance to review it. We discussed this a couple of meetings ago, but ultimately attempting to make a recommendation for uniformity as to how motions to substitute are treated, both from a clerk's perspective and also, frankly, as a practical matter. I cannot tell the committee how annoyed I am, just by way of anecdote, where I've got a file where I think I represented the lender three versions of the lender ago, but because of it's a clerk's office that just adds the substitutions, I still keep getting notices about it, and I know I'm not alone in that regard. So ultimately getting some uniformity on how motions to substitute should be properly reflected in the docket has both a practical impact and even when you think about mailing notices for those, I highly doubt that many are getting mailed. There could be a more than practical impact in terms of not needing to send notices to unnecessary entities. Anybody have any questions about it? I believe it fairly accurately reflects the conversation that we had when we last talked about it.
Anyone have any questions for Attorney Pocklington or comments?
I am, I'd say probably 99% in agreement. My only concern with Attorney Pocklington's proposal is the removal of the prior entity completely from the docket, if only for a possible confusion as to parties involved in the case. I understand completely Attorney Pocklington's concern over prior parties still being listed with the appearances in place and getting notices for a party that's no longer really involved in the action. My only concern is that if someone looking at the docket were to say, okay, this is the plaintiff, but they're listed as plaintiff 3, I'm not sure why there is no plaintiff 1, plaintiff 2. I think this has probably come up with the recent merger between our firm and Brock and Scott, where the plaintiff 1 is still represented by Bendent McHugh, which technically doesn't really exist anymore, but then the plaintiff 2 is represented by Brock and Scott, but it's essentially the same entity. My only concern would just be with removing completely the party that was previously involved, just for an issue of clarity. But overall, I don't have any issue whatsoever with what Attorney Pocklington has put in the document.
And
Yeah,
I think
and
that
I don't,
oh, go ahead.
I
Judge
don't
Fader.
think that's a 99% agreement with Attorney Pocklington.
All right,
Because
we'll go with 75%. I'll go mostly agree with Attorney Pocklington.
Because that's really my only concern also is I kind of agree, but I agree from the perspective of the lis pendens statute, 52-325. You have a lis pendens on the land record, that's in the name of the original plaintiff. And when someone is supposed to be on notice of litigation and go to the judicial branch website, if that first name disappears entirely, did the lis pendens really give them notice of the substitute case? So now, but again, I agree with you. I don't like that all these appearances keep showing up in the file, but I kind of think if we leave P1 in there, but the question is what's going to be reflected ultimately on the judicial branch website when someone looks at the case? Should it be in the original name or should it be in the substitute name?
So my intention on this, the reason I wrote it the way I did was based off in my experience, once if a party is removed, they still remain on the docket, but are noted as having been removed. So what I'm looking at an example, and I'm going to throw this into the chat right now if that's acceptable to everyone. Hopefully it formats properly. That did not format properly at all. But it still shows PO. The instant action just was one I coincidentally had on today. And it still shows that the PO1 was JP Morgan Chase, and then but that's almost grayed out, and underneath it in red text is the word removed. There is no appearance information, just the entity. Then PO2, new lender, full identity, new lender, attorney, filing date, party category, et cetera, is completely. I wish I could figure out how to make this work with the chat so it's
You know what?
easy visually.
I'm going to suggest that you can take a screenshot of it and maybe send it out by way of email. That might be easier. But because I share the same concern that Judge Spader just raised, but I understood your third suggestion to be just that. In other words, almost making sure that the parties are all still listed, but it's clear which ones have been removed and which ones have been substituted, like you see in the civil cases.
Exactly.
And I'm in
just to be
99,
clear,
then I'm in 99% agreement, even though
Just to
George
be
is
clear, I
70%.
wasn't suggesting that the appearances should still, if what Attorney Pocklington was suggesting is that the individual parties still be listed and then the appearances be removed for them, I'm totally in agreement with that. I just read it as removed, as in they would no longer be listed as plaintiffs in the case.
That's option one. He has three options. And again, Attorney Pocklington, if I misunderstood, let me know that. But I read this one of addition of the substitute plaintiff as a subsequent plaintiff and the removal of the prior plaintiff as a party as if it had been withdrawn as a party. So in other words, what you were saying is that everybody would still appear, but it would have the notation underneath it to say removed and not the attorney anymore. So they'd be listed still, so that, because quite frankly, the judges look at that too. It's not an end all and be all, but it's a quick sort of cliff notes to see where things stand and who's involved in cases. Is that what you were saying?
That's exactly what I was saying. So that the header information on the proposal listed the three different ways that I've seen this done. The third option, which is the addition of the new entity and then the removal as opposed to a complete overwrite, was what I saw was the best solution. That's what I believe we discussed last time, but we all thought that that was the best solution as well. And if I didn't properly articulate it, well, sometimes I do that. I apologize, but ultimately,
I probably just didn't understand exactly what you were saying. So that's totally fine.
You know what? Actually, Becky, you should by now have a copy of Attorney Pocklington's email.
Yeah.
Can you screen share it? Because that shows, I think, a better visual of what he's. I don't see an option for me to share on the top of my team, so I can't do it. That wasn't it. It's an email. Did you copy her as well?
It's a document. I have it as a document.
Oh.
You do?
Is it? You sent me a Word document, correct? Attorney Pocklington?
No, it's
About
in the
2
body
minutes
of his
ago. Here we go.
email.
Okay, let me find the email.
You're in there.
This would have come in just now.
Like
I just got it.
moments ago.
Oh, got you. You're sharing the screenshot. Sorry. Apologies. Apologize. Teams is being very, very slow. It may be this. Hopefully it is.
There we go.
Okay.
So you see that, so the party name is there, but it shows that party has been removed and there's no longer an appearance shown for it. And then it has the substitute plaintiff identified as plaintiff substituted for P2 with the appearance.
So I'm going to get 75% of the way there for the clerk's office perspective.
Yeah.
Because it alters the record. I know that there are offices that are doing it. I would say that it's not a best practice for clerks because they're removing a party without any order or anything beyond the actual substitution. If there's an issue with the substitution or for whatever reason the substituted party needs to file something, they cannot. We've effectively removed their ability to do so. So I think it may be a workable solution, but I think that there could be the possibility that there needs to be some sort of rule change or statute so that it works like an auto withdrawal so that the clerk has something to fall back on for doing the removal. And again, I know that it's happening in locations and there's a difference of opinions about whether or not it's appropriate. I don't think it's necessarily something that's ever been explored from a rule perspective, but I am aware my family knowledge is not great and this is not a family committee, but there are some auto withdrawal rules where after a certain amount of time, the appearances come out and things like that. So the clerk, by doing a removal, is effectively altering the record and impacting PO1's ability to ever do anything VE file if they ever had to. And it has come up. It doesn't come up frequently, but every once in a while, districts that do remove parties have had to restore their access so that they could do whatever it was they needed to do. Whether it's, I can't even tell you what the motions would be, but we've had a few of those inquiries where we've had to go back and have them restored.
So let me just say this, and I appreciate the reference to family, but family's kind of a different animal because you do have limited appearances. I know, Judge Spader, you're there now and you can comment on this, but there are limited appearances also, and there are other issues there. With this one, even if it were a limited scope, so for instance, where we see it in foreclosure is ordinarily, and it can happen in other instances, and please folks pipe in if I miss anything, but where there's been an assignment and now the attorney, who is more often than not the same attorney who was representing the prior plaintiff, is now representing the substituted plaintiff who has become the substituted plaintiff because there has been an assignment to them. So it's the same firm. It's the one plaintiff, but because of the way foreclosure works, the assignment, that person who receives the assignment is now the one pursuing the action. So the odds of there being any issue of McCalla Raymer or Brockton Scott having to file something on behalf of their prior plaintiff who no longer has the interest in the debt are slim to none. So it would seem that that is not a risk that would be associated with foreclosure motions to substitute, which are treated differently. You don't even have to file a substitute complaint. You know what I mean? I mean, it's just different. Did I fairly state that? Is there anything anybody wants to say?
I would just add, completely agree. And just for perspective, I don't have any numbers to back it up. This is purely gut, but I imagine we're all very experienced practitioners. I would be shocked if the sheer number of motions to substitute in foreclosure matters didn't, we're talking a factor of probably 10 compared to other civil actions and family. In terms of assignments of a legal cause of action on a tort claim have to be very few and far between. Similar with family, I cannot imagine that mortgage foreclosures, because of the prevalence of assignments in the industry, do not have the vast majority of motions to substitute in the state.
I think that's fair. Anyone else? So, thoughts about moving forward with a proposal? Such a chatty group. I know Attorney Pocklington's in favor of it. Do I have to call on you one at a time?
I think it is something that would be useful, and I think if Attorney Pocklington makes the motion, I would second it.
There you go. Attorney Pocklington?
Just don't want to cut off conversation before I do that. George, Jeff, are you?
Don't worry, I'm going to go back into discussion after you make your motion.
I move that the proposal as written be adopted by the committee.
I will second that.
Okay, George second.
Oh, George seconded. All right. All right. Now, any further discussion? All those in favor signify by saying aye.
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 All right. Any opposed? Any abstentions? Motion carries. What I'm going to ask then, Attorney Pocklington, are you comfortable putting your, we could just one of two ways. You've already given us all of the information. We've had a discussion about it. I can put together the proposal to send to Judge Bellis to ask if she endorses it so that we could send it on to the Chief Court Administrator. Or if you prefer, I can have you send me a proposed draft of just what we're saying. I mean, it's either way is fine. I'm comfortable with either way.
I don't have a strong preference either way. My recollection, and I may be about to not to point the bus at you, as it were, but my recollection, it's been a couple of years since I've been in front of Judge Bellis. I don't remember, what I don't remember is whether she's the type to want all the background in a proposal or just short and sweet and just the fix. I'm looking at, for example, the Word document that I gave you has, as I said, it leads with these are the ways it's being done. Here's the authority, here's the recommendation. I don't know whether it makes
Yeah.
more sense to just under just the recommendation or the whole kit and caboodle.
All right, so why don't I work with Becky? I think that some kit and caboodle is helpful to put it into context, but too much probably will make it a little bit more difficult to keep attention on the focus of our issue. And so why don't I work with Becky to synthesize this down into a short submission as to the recommendation of the committee. Is that okay?
Thank you.
All right, excellent. With that, unless there's any new business, I would entertain a motion to adjourn.
I can make that motion. I just wanted to say for January, I will circulate something ahead of time on a few things, but I have learned in the last few months something I didn't realize, which we are relatively unique in the 50 states of holding foreclosure sales at properties and posting sales on yards. So I will circulate some info. I'll send it to Becky to make sure I'm putting proper filters. Send it to Becky and then perhaps something for us to consider in January.
Okay, great. And if anyone else has any other ideas that they want us to address for new business at the next meeting, you have plenty of time to consider it. But just try to get that to us if you can before the holidays so that we're not inundating Becky as we get too close to the meeting. But certainly we're always open to hearing if there's new issues that you want to raise.
I do actually have one. I'm sorry. I know we were getting ready to adjourn. And
no worries.
Clicked. Just want to make everyone aware. I'm sure this is already on George's radar, and I assume on Jeff's, but I don't know if the other practitioners are aware of it or the judges. The HUD has what they refer to as their drafting table, which is where they put out proposed rules for public commentary or industry analysis. HUD issued a item on the drafting table a little bit ago that's still in that period that is potentially of concern to the process. Ultimately, what they are proposing, and I'll circle to why it matters. What they are proposing is that when a lender with an FHA insured mortgage sends a payoff statement on a loan that has been modified through a partial claim, that's those standalone HUD second mortgages, often why you see the U.S. as a party in a case, that the lender is required to make certain representations as the amount needed to also satisfy the HUD second mortgage, even though it's a separate instrument, separate, separate servicer, et cetera. There's a lot of questions about what will play out in that regard. Frankly, I have ethical concerns because I don't represent HUD. So if I get a request for a payoff, how can I tell the homeowner what they would need to pay off their HUD second mortgage? But I am somewhat concerned that there may be implications on affidavits of debt if a lender is required to include the amount needed to pay off the HUD second mortgage as part of any transmission of amounts needed to pay off the first mortgage. It's an ongoing discussion, but it's one that may come to a head before our next meeting. So I wanted to just make everyone aware of it so that if there are emails about it, and frankly, the impact that may have, because I can only imagine affidavits of debt that refer to more than the subject mortgage's debt being very questioned by a number of judges, so that you guys are aware, so that if it does go that sort of worst case route, we can discuss how to get the necessary information out there. And I don't know whether this was on anybody else's. I know, like I said, I'm sure George was aware of it, but I don't know if it was on anybody else's radar because it's just on the drafting table at the moment.
All right. So you know what I'll do for the next agenda and maybe for ongoing agendas under new business if we have something identifiable, I'll list it, but I'm also going to ask Becky that we have just a standard sub point that just says other business. Because technically under the agenda, we can't discuss something if it's okay. Because you're talking about things for a future agenda. We can't talk about things if they're not on the agenda. But if we have other business and something comes up, it gives us the opportunity to do so. We can certainly put this, it sounds like at this point, you're not sure where things will be. So maybe we'll just put under new business, potential update by Attorney Pocklington relating to the FHA second mortgage issue. Is that okay?
I'm nice and succinct.
And I
saw
appreciate the
Judge
heads up
Bader
on that.
lean in to talk. So
Great.
Yep. Yeah, no, I appreciate that.
Much appreciated.
That kind of information is good because those questions come up and I'm able to assist.
Great.
Thank you.
No, that's
I promise
and
motion.
that's perfect.
So returning to Attorney Gentis's motion to adjourn.
Yes, I promise to move to
I will
adjourn.
second that. I will second
Great.
that.
All those in favor, the hands went up readily. Thank you so much, everybody, for your time and for a really great meeting. Have a great rest of your week, and we will be in touch with you soon.
Thank you.
Thanks.
Bye.
Thank you. Take care.